What is an information disclosure statement in a patent application, and why is it crucial to your patent application? Well, an information disclosure statement is a statement that you must make in a patent application if there is information that's material to the patentability of your invention, of the subject of your patent application. What is material information? Well, it can be just about anything. It can be US patents and US patent applications. It can be foreign patents and foreign patent applications. It can also be anything else that bears on whether your invention is patentable. Now, this list could be things like journal articles, white papers, crowdfunding campaigns, social media posts, other products or services that are on the market that you know of, and really just about anything else. Okay, that's what an information disclosure statement is. Now, when do you have to file it? Well, you don't have to file it exactly when you file a patent application. You can file it up to 3 months after. And, well, there's a good reason for that, because sometimes you need to file an application in a hurry, and then you get the 3 months to gather the info that goes into the information disclosure statement and file it. Now, if your patent application is already pending, there are still opportunities to file it, depending on where your application is in the filing stage in examination. Have you gotten a first office action or not? Have you gotten a final office action? Have you already paid an issuance fee? And the ability to file and whether and what the fee is that you have to file as a penalty for late filing of the information disclosure statement depends on both that stage of the application and also on when you learned of the prior art that you need to disclose. If it was recent, within 3 months, there may not be a fee. If it was more than 3 months ago, there probably is a fee. That's when you have to file an information disclosure statement. Now, how do you file it? Well, it's important that when you are preparing the application, you give good invention disclosure to your patent attorney. This means tell the patent attorney about what you know of and how to find it. If it's patents or patent applications, that's relatively simple. You list those on the form. If it's something else like a white paper, a journal article, a product or service that's on the market, you'll probably have to provide information on where and how the office can find it, and also a copy of it. And when you are preparing the application, it's important to provide this info. As I mentioned, if it's an emergency, then you can provide it later after you've gotten the emergency filing in or a filing to beat a deadline in. And also keep in mind, if it's something that you learned about after you've got an application pending, it's important to tell your attorney about it as soon as possible so that you can prepare and file an invention disclosure statement, hopefully before a 3-month deadline, and therefore avoid having to pay an extra fee to the USPTO for it. Now, along with the requirement that you disclose this info, whatever it is, in the IDS, that's the information disclosure statement, it applies to anything that you, as the client, the inventor, the firm, know about, as well as anything that your attorney or the law firm knows about. There are other advantages to you besides the requirement in filing it. For instance, it can strengthen the patent application because you won't spend time talking in the patent application about information that you already know about, that's already patented or that's already described somewhere, because you're not going to get that patented. You can focus on your improvements. Also, it can lower the cost of the patent application because you don't have to spend time describing things that are already known. You can phrase your application as, here's something we know about, here's a problem with it, and here's why our invention solves it and is better, and therefore deserves to be patented. And lastly, this can also help prevent your patent from future attack once it's issued or during the examination process, because if someone tries to invalidate your patent by saying there's already known prior art that's out there and so this shouldn't have been issued, you can say, no, we disclosed that. The office knew about it and we had it considered during examination. and our invention was still found to be patentable, even in light of this prior art that was known. If you've got questions about an information disclosure statement, about the importance of them, what goes into them, how to prepare them, let me know. Thanks for watching, and as always, have a great day.